Good afternoon, everyone. My name is Steve Jewett. I'm a county court judge in the Ninth Judicial Circuit of Florida in Orlando. Welcome.
Good morning. My name is Doreen Hartwell. I'm an attorney in Las Vegas, Nevada.
Good morning from Oregon, where it still is morning. I am Erin Lageson. I am the presiding judge of Department 3 of the Oregon Court of Appeals, which is Oregon's intermediate state appellate court. And very excited to hear from you this morning.
And the team members?
Hello, good morning and good afternoon. We are all outgoing seniors. My name is Victoria Torres.
Hello, my name is Amanda Herrera.
Hello, my name is Lily Marie Quintanal.
Hello, I'm Julianne Mendez, and we're very happy to be here today. And thank you so much for your time, judges.
All righty. Okay, folks, we're here, obviously, Unit 5, and we'll be doing question 2 today. The question reads as follows. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and in what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson, who made that statement? In addition, what are the advantages and disadvantages of a national Bill of Rights as compared to a state Bill of Rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You have 4 minutes.
A Bill of Rights is necessary to not only list the rights of the people, but to protect them as well. In this way, I see eye to eye with President Jefferson's sentiment. During the Philadelphia Convention, it was believed that what the Constitution lacked was a formal document in which outlined the rights of the people. The Anti-Federalist experiences with the writs of assistance, the Stamp Act, and abuses of governmental power all culminated into their writings. After the convention, 10 of the 19 amendments presented were ratified, and thus our Bill of Rights was established. The Bill of Rights has even influenced the United Nations Declaration of Human Rights, in which promotes civil liberties amongst all nations. Much like the United States Declaration of Independence, the Bill of Rights has drawn great influence from the idea of unalienable rights popularized by John Locke. Without our Bill of Rights, the Constitution would not be the social contract that it is today between the people and those that govern.
When the Anti-Federalists advocated for a Bill of Rights, it was because they feared that the national government created by the new Constitution could grow to overpower the sovereignty of the people. The National Bill of Rights has several advantages when compared to state Bill of Rights. It protects the people from an overpowering and abusive federal government, and it creates a fair and equal standard that must be followed by each level of government. This national standard, which would not exist if only state Bill of Rights were created, prevents the government from having boundless power on the infringement of our rights. As it is written in the Anti-Federalist Papers, what then may we expect if the new Constitution be adopted as it now stands? The great will struggle for power, honor, and wealth. The poor become a prey to avarice, insolence, and oppression.
Simultaneously, the National Bill of Rights does have its disadvantages. The 10th Amendment focuses on the relationship between the state and the federal governments, overall stating that any rights not listed in the Constitution will be granted to the state governments. Some of these rights can include education, marriage, privacy, public health, recreational use of marijuana, all things varying depending on the state that you're in. The Federalists were in opposition to the idea of the National Bill of Rights because they knew that the states would have total control over any rights that were not handed over to the central government, no matter what. 328.8 million people stand on this land in 50 different states and demographics. It would be impossible to have sole and total control over these entire population groups without the 50 state governments, who hold a closer perspective and idea on their people and their needs. The state's Bill of Rights has a direct focus on its individual population groups. They also have a direct focus and they also have a direct impact on its people, unlike the national government may not have sometimes. And federalism does have its advantages, yet it is important to recognize some of the struggles that the national government and the National Bill of Rights can go through when dealing with certain issues and its impact on its people.
The right to free schooling, healthcare, and employment. Positive rights are those that require government involvement to constitute a nation of opportunity. Meanwhile, civil and political rights, such as those addressed in our Bill of Rights, are considered freedoms that cannot be infringed upon by our government. These are known as negative rights. At times, the line between the two can often be blurred. Basic freedoms include the elements of both negative and positive rights. As a result, a blurred line between positive and negative has continued to define our liberty. However, it is important to recognize that without the ability to implement negative rights, it would be impossible to expand our positive rights. Congress shall make no law that infringes upon. These words promote the fundamental ideas that our country stands for: justice and equality. Thank you.
All right. Did one of you guys want to go first?
Sure.
All right.
What limits, if any, should be placed on the rights that are contained in the National Bill of Rights, and who should place them there?
I definitely do believe that there have been some limitations that have been placed on some of our amendments in our Bill of Rights, which have been brought upon us by some Supreme Court cases. Some of these can be with the First Amendment, our freedom of expression, our freedom to protest, to petition. These have been cases that have been brought upon and have made examples on what is seen as peaceful, what is unpeaceful. There have also been limitations that have been brought upon our Fourth Amendment, and some of these cases can also deal with the state government and the national government. Some of these cases can, it's just a variety of things, such as Wolf versus Colorado. It deals with the Fourth Amendment and our unreasonable searches and seizures.
Yes, to continue speaking about the Fourth Amendment, there is a limit placed on it called the Exclusionary Rule, in which if evidence is obtained illegally during an arrest or in somebody's home, it cannot be used in state courts. So I feel that that is an important limit placed on the Fourth Amendment.
So,
What, go ahead.
oh, okay, thank you, Stephen. What circumstances, if any, would cause a person to lose some of the rights found in the Bill of Rights?
Well, the 14th Amendment says that no individual can be deprived of their rights without the due process of law. So there are instances where an individual who goes through the due process, maybe is convicted of a certain crime, does end up losing some of these liberties. Maybe whether that be through the form of imprisonment or another form of punishment, they may lose the rights, some of the rights that people who haven't been convicted. And, this isn't necessarily in the Bill of Rights, but we've seen the right to vote, at least in Florida. It's highly contested whether the right to vote for felons, that's a highly contested issue in Florida. So there are instances where a person who goes through the due process of law loses some of these liberties that people who maybe haven't been convicted of crimes have not lost.
It's also important to recognize that an individual's rights end where another individual's rights begin. And this sentiment is important because if one is impeding on the rights of another, that would be an instance where your rights would also be limited, because it is not fair for one to have more rights than the other. Going back to the 14th Amendment is equal for all. So in order for one to have more rights than the other, it is not fair. Thus, if you impede on another's rights, your rights would also be limited.
I want to ask just a little follow-up with that. With regards to where one's rights ends, where another's begins, how do you think the question of the mandatory vaccination comes into play with regards to that? Individual rights in the Bill of Rights.
Well, this issue of mandatory vaccination, there are two sides to it. Where one side argues that it's for the common good and it's for maybe even public safety or public health. The other side argues that at its core, there's still an individual liberty as to whether a person wants to get vaccinated, whether the person should still have the choice. So in regards to what my colleague said, that somebody's rights end where others begin, one could argue that although the public has the right to public safety and public health, individuals also have the right to choice, to choose whether they want to be vaccinated.
In the preamble of the Constitution, it mentions ensure domestic tranquility. So I feel like what my colleague is also saying, and provide for the common defense, and all of the things in the preamble are just like in regards to the vaccinations, we must keep in mind that this is for the general good, for the common good. And although it does limit some people's rights, this is again hotly contested. It is for what the founding fathers are standing for as in regards to the preamble.
To add on, it's not just with the vaccinations, but it can also be seen with the mask mandates when it comes to the COVID-19 pandemic. And we do have to recognize that public safety and public health is also an issue of the states. Although the national government has tried to work hard on the mask mandates and things to enforce upon its people, it is something that has been given to the states and something that the states have control over at the end of the day.
All right, what's the difference, if any, between rights that are added through the amendment process and those that are established by court decision or referendum? You know, in Florida, you know, we can, if we get enough signatures, we can put something on the ballot and add it to our Constitution, which we've done probably too many times in my mind. But what's the difference between those three? Are any more valid than the other? And how about the enforceability?
Well, I think that they are all valid. And I think in different ways, they all serve either a representation of the people's desire, representation of the legislative branch's desire, which is elected by the people, or a representation of the judiciary's desires, which is chosen by the president, confirmed by the legislative branch. In terms of enforceability, I do see why maybe a Supreme Court decision is much harder to enforce. I know at the end of the day, there have been instances where the president, the executive branch, maybe does not want to enforce judicial decisions, or Supreme Court decisions. So I see why that can be an issue with enforceability. I mean, we can look at, for example, the Supreme Court case Roe versus Wade. It ruled that states cannot outright ban the right for an individual to get an abortion. But we have seen instances where states have made it extremely difficult to get an abortion. So we see this kind of conflict between the Supreme Court making a decision that expands rights and it not being executed to its fullest extent, whereas an amendment, it would be maybe easier to enforce because it is something that has already been made into law.
To add on, oh, you can go.
You can continue.
Thank you. To add on, another example of this can be the right to privacy. Although we do have our 4th Amendment and our 9th Amendment, there is no established amendment that focuses on our own individual right to privacy. And there has been cases brought to the Supreme Court having to do with this, such as Griswold versus Connecticut. And it is something that is brought up in our state's Declaration of Rights, our state's Bill of Rights, such as in the Florida Bill of Rights. It is mentioned in one of the sections, but it has been a right that has been brought upon us because of the Supreme Court more than an amendment itself.
And when you mention that really quickly, what happens if the states have a more protective Bill of Rights that give more rights to their citizens than the federal Bill of Rights? Which one wins out? Who gets
That's where the supremacy clause comes into play. It's usually seen as the federal government is the more supreme. They're the ones who...
You can finish your thought. Go ahead.
Thank you. They're the ones who usually tend to make the final decision because they're the ones who are granting the people more rights. However, if the states are reasonably like giving its people more freedom, more rights, then the states will win in that case.
Okay. Right. That's right. I was afraid you were going to go the wrong way, but that's absolutely right. Right at the end, you saved it. Good job, you guys. Excellent. Way to go. Well, I'll go first. First of all, I know one of you. You were in mock trial.
You know a lot of them.
Some of these kids were in mock trial, and I just saw them like, what, 3 nights ago? I don't remember which one it was. So as soon as you guys came up, I'm like, okay, you look kind of familiar. And then I'm like, oh yeah, I definitely know them. Now, it's not going to change anything, but first of all, congratulations on making state finals and mock trial, and then also making this national finals. Unfortunately, you didn't get to go to Virginia, but if you're not seniors, maybe you can go next year because it's a lot of fun. Anyways, really, really well done. I think this question, we did the question last night, which of course you did too, was about the other question about establishment of religion and stuff. I think that's an easier question because it lends itself more directly to just having case law and talking about stuff. This one's a lot more esoteric and dealing with thoughts in the what rights and types of things like that. So I think it's a little more difficult, but I thought you did an excellent job in your opening because you explained in a very general way or very layman's way what exactly the Bill of Rights does. It lists and protects. That's perfect. That's important to know. And then it goes through and talks about the Anti-Federalists and why we needed to have a Bill of Rights and how that came about. A lot of people don't know that. A lot of people think that it was just all part of one thing and it was there. So I think the history part is great. You were really good. You guys listened to our questions and answered our questions. It wasn't, you didn't just try to, if you jump off into some sort of stock answer, which is always bad. And then, like I said, Lily Marie, that last question I asked you right there, that's for us, we do have the right to privacy in our Constitution in the state of Florida. I'm sure the legislature doesn't like it, but it's there. What can you do? Unfortunately, the Supreme Court of Florida is probably not going to change anything based on that. But I digress. Anyways, a very good job, excellent. You make me proud to be a Floridian.
I thought you guys were excellent. It was such a pleasant way to start off the morning. Each of you, your prepared remarks, you all had just great presence. There are so many times that when we're done with this and one of our comments to the other teams are, slow down. No, you guys were great presence. And you just spoke really, really clearly, and it was really well done. I thought you answered everything. With regards to your prepared remarks, you really thoroughly and completely answered the questions. That was great. You covered everything, and as Stephen said, you had the historical background. You mentioned in the Anti-Federalist Papers, you covered and you stated clearly the advantages and disadvantages between national Bill of Rights versus state Bill of Rights. I think and you did, even though, as Stephen again said, this didn't lend itself to a lot of Supreme Court precedents, you still did use law with examples when responding to our questions. Your responses I thought were really good. I loved how you answered my follow-up question with regards to the vaccination, and the fact I thought Amanda's response was great. Then I thought, I think, or could have been Lily Marie, who added in the mask mandate. I loved how you came in and even expanded it further. I just thought you guys did an excellent job, and it was just a pleasure, a total pleasure this morning. Thank you.
I completely agree. It was a great way to start the morning here, start your, hopefully for your afternoon. I agree on the pacing of your prepared. It was very easy to follow, but I also like that you had quite a bit of passion in your tone. It sounded like you really care about this stuff. One thing that struck me is you sound like you're all criminal procedure experts. I heard about writs of assistance. I heard about the exclusionary rule, about the Fourth Amendment. So I love criminal procedure too. So I wish we'd had more time to discuss that, and in particular, the way the different states have gone about protecting criminal procedure rights under the state constitutions, because there's a lot of variation there. Beyond that, one thing I thought you did particularly well, and I think Amanda's response to Doreen's question illustrates what this was. You pinned your answers to the Constitution. Doreen asked about, how could rights be taken away? And you could see you analyzing it with due process protects liberty. So to do it, you have to go through process. And so you started general, pinned it to the document, and then added more specifics both to that question and the follow-up. And so I thought that was pretty agile of you. So nice job.
Well, of course they're criminal procedure nerds. They're mock trialers. Not to mention the fact Lily Marie was charged with murder this week.
We did not know that.
You were the defendant in the trial, right? Yeah. So All right, well, very good. I wrote down here, I like when you talked about the blurred lines between the positive and the negative. That's really kind of what this whole question goes to. So I did like that. So excellent job. Good job, you guys. Good luck today. I
Thank
know
you
this
so
is your
much, and we
first
really
bid today,
appreciate your
so same with us.